Good afternoon, and thank you for joining us today. I would like to welcome you to the third and final part of FortneyScott's Workplace Legal Compliance webinar series titled Trump Administration Increases DEI Pressure. Today's presenters are FortneyScott attorneys Leslie Silverman, Nita Beecher, Sarah Mugman, and David Fortney. I will now turn the program over to David to start the webinar.
Sarah, thanks so much. Welcome, everyone, and it's great to be here with Leslie and Sarah and Nita. We have a lot to talk about, and as Sarah indicated, this is the third of our three-part spring series. When we stood that series up to talk about workplace compliance, we actually had a discussion, do you think we'll have enough material to cover? Has all the developments occurred? Well, it shows what we know. We've been overwhelmed with developments. So we have a lot, and certainly the tying it off on DEI, I think is very appropriate because that continues to be one of the hottest areas, I think, that the administration has in its policy priorities. Let me just say a word quickly about who we are. Next slide for that. Those that don't know us, the firm, and we're of course based in Washington, D.C. Many of us did have experience in prior agencies. Leslie as a prior EEOC vice chair and commissioner, and also Hill experience and a lot of other very deep labor employment experience.
A lot of years of cherry blossoms.
A lot of cherry blossoms. Yes, we're very much into the cherry blossom mode this last
So
week.
it is freezing here right now, but they're still pretty.
A little cooler than it should be, but they stay longer that way. But also, and Sarah, we really are very fortunate to have a super deep bench with Sarah, very highly experienced, and Nita Beecher, who has been doing this a ton of time and are integral to what we do. So we do bring that experience and expertise to dealing with multiple agencies, and that certainly is helpful, I think, as we try to unpack what is happening with DEI, and it's helped us. Let me just quickly cover the agenda because we have an hour and we want to really make maximum use of our time and more importantly, your time. First, we want to level set, although we have a new executive order on DEI, we'll kick off with just a quick foundational element to make sure we do have good understanding of the DEI EOs, executive orders. Second, want to really delve into some of the federal agency actions. There's a lot going on. It used to be we'd just talk about a single agency. Well, of course, as you can see by the list, that's not the case now. The states are also stepping up their activity, and I think for employers understanding their compliance and potential exposure areas, states continue to be a part of a high-risk profile, certain states. We'll give you a quick take on that. And then, because we have been sleeping little and doing a lot of this over the last couple of weeks, we want to give you some takeaways from our experience that we've been having. And we've been dealing with a lot of clients that are very anxious on these issues, understandably, and just share with you some of those lessons learned, which I think people always value. All right. Well, let's jump right into it. And Sarah, I'm going to ask maybe if you can jump us off. We have all the executive orders begin with 14, so we've got 168, 173, and 398. the three DEI EOs. So yeah, let's start. So give us an overview of those, if you would, please.
Of course. Next slide, please, too, when you have a moment. So we've got the first. We want to briefly mention to reorient is, of course, quite a mouthful. It's going to be defending women from gender ideology extremism and restoring biological truth to the federal government. So here, this executive order President Trump had issued on his first day in office, and it really just directed the federal government to recognize only two sexes. And so while this wasn't necessarily employer-facing through its text, it nonetheless kind of signaled that this administration was going to approach identity-based considerations in its policy in a particular type of way. Next, we would have Executive Order 14173. This has, of course, been the topic of a lot of discussion and various litigation over the past, 15 months or so. And this really marked kind of a shift for employers, particularly federal contractors. As you all likely recall, it had revoked the Executive Order 11246, ended federal contractors' obligations related to maintaining affirmative action plans, but it also required federal agencies to certify that they don't operate DEI programs that violate applicable federal anti-discrimination laws. And those certifications exposed contractors to false Claims Act liability, potentially. So that kind of brings us to our newest executive order issued just a couple weeks ago, which is addressing DEI discrimination by federal contractors. And so we'll discuss it in more detail shortly, but I just want to note here that it appears that it was intended to build upon 14173 because it really reframed and defined the DEI it prohibits as racially discriminatory DEI activities. And it also really prescribed a standardized contract language that all federal agencies need to include in federal contracts, rather than kind of relying on the more generalized requirement that we saw in certification language in 14173.
Agreed. And I think, I mean, 173, and Nita can give us a rundown on kind of where the courts have been on some of these issues, but 173 has been subject to, it was fairly broad. It did introduce the concept of illegal, DEI, air quotes or literal quotes, I guess, around the word illegal. That's not a phrase that we were talking about before this administration, and trying to understand what that meant. It also introduced the False Claims Act. So those kind of foundational elements in the Trump policy have continued to animate a lot. There are some throughput, not everything is ad hoc, and that's part of what we've been trying to do is kind of pull out what the throughputs are, cut through the noise and get to the direct signal, and it's beginning to shape up. I'm not sure we're all the way there, as you'll hear, but we're getting there. We're getting there. Well, let's talk, Nita, some of the litigation challenges, because there's been a lot of litigation.
Well, and I think it's important going to the next slide. One of the reasons we believe that we now have the new executive order has to do with all the legal challenges around 14173, which was very vague, and it wasn't, and there's been no regulations issued as of yet. Although the Fourth Circuit upheld it from a constitutional perspective, they were really just looking at the language itself. The Seventh Circuit, in an oral argument on the same topic, was questioning the DOJ over what was the definition of illegal DE&I, which I believe is why we have a definition at this point. And many of the district courts have blocked the ability of the federal government to not provide money in grants and loans and others based on the certification requirements. So there are hundreds of cases out there around 14173, and I believe that that's one of the reasons they've decided to take the shift to the new executive order.
Yeah, I think that's right. I mean, most administrations don't want to rescind or modify their own executive order, particularly after only effectively 12 months.
Yeah.
So you simply issue a new one and kind of pick up, and it is certainly, we'll discuss that.
That's going to make for some confusing litigation.
It will indeed. It will
Yeah.
indeed. Well, this certification point, because contractors over the last year I've been a little bit betwixt and between about what the certification requirements are and the new ones. And let's jump
slide
quickly. Yeah, let's look at the next slide. Give you just a quick update. About a year ago, almost to the day, there was a proposed regulation, and it didn't have great regulatory text. It was just, we're going to issue a regulation, we're going to implement what was then the new executive order 14173. On one level, maybe it just meant we're going to scrub off or erase the references to the former 11246 and all affirmative action obligations. Maybe it was something more fulsome. Certainly on behalf of the Institute, we were very active in going over, meeting with the regulators, or trying to meet with the regulators. Some of them weren't necessarily interested in talking to us, but we nonetheless did try. We had 2 meetings at the White House over how that process, what it might look like. Again, it was sort of a weird process because we didn't have any regulatory text. It was just announced we're going to do a regulation. We actually had advocated a safe harbor approach that would have allowed people to have framed up, and we tried at that stage to stand up what is the definition of illegal DEI, which was an undefined term. Well, that whole effort, and then there's been radio silence for months after that, which was also candidly a little weird. But at this point, we now know what happened to that rule. Nothing. It has officially been withdrawn. So thanks. You get a little pat on the head. Good effort. We're no longer even on that page. And so the whole effort has changed. There are new certifications afoot, and the first one, Nita, deals with GSA.
Yeah, this is a really interesting one. Sarah's going to talk a little bit about the details on the new executive order. This GSA proposal, which would implement a requirement that those who receive financial assistance from the government, very big group of people, grants, loans, et cetera, like that, would be required in the SAM.gov database to certify certain things, including, interestingly, that they are not engaged in unlawful discrimination on the basis of race or color in the administration of federally funded programs, citing specifically Title VI and Title VII of the Civil Rights Act, among others. Now, interestingly, this again is focused on illegal discrimination. So they're tying this all back. And it goes through a series of examples of what they consider to be illegal illegal discrimination based on race or color. And then somewhere in here it talks about race and ethnicity. So it's a little bit of a hodgepodge. The comment period has closed. Again, this is proposed. Comment period has closed. I don't know about you all, but I would not be at all surprised to see this one pulled as well and recalibrated based on the new executive order.
There is one thing that is in the, I'll call it evolution of how the administration's attacking DEI. These most recent efforts, the GSA proposal, the new executive order, are focused on race. And we have now cleaved off the other component, Title VII protected categories. So sex, national origin, religion, all that was sort of initially in as part of the illegal DEI, the quote wokeism statements that were around. And I just would highlight that some of the potential examples of practices that may violate, this comes off the GSA proposal, any preferential treatment, okay, whether it's scholarships, programs, preferential hiring, and I think people understand that preferential treatment. Any segregation based on race or color, like training sessions, facilities, resources, those don't strike me as being terribly controversial. Other ones that sort of caught my eye, though, were race-based diversity slate policies in hiring. Okay, diverse slates. Does that mean diverse slates that operate in violation of Title VII or any diverse slates? Not clear. Training programs that stereotype, exclude, or single out individuals based on protected characteristics, and of course, retaliation. So some of those are, I'll call it garden variety. Others potentially may go a little further. Nita.
And I think these really come out of the Bondi memo from July of, I think most of those are examples. And it'll be interesting to tie those into what Sarah's going to talk about in a minute in the new executive order and how that is set up quite differently, I think, Sarah.
Yeah. So let's get into that. 398.
Yeah, next slide, please. So I think here you'll see the first thing we want to know, just these are the key elements, I think, of this new executive order we want to discuss. So the first is going to be that at the outset, we've got this order that grounds the president's authority in the Federal Property and Administrative Services Act, the Procurement Act, right? So that is what authorizes a president to impose requirements in federal contracting to promote economical and efficient federal procurement systems. So they're kind of anchoring it as within that authority. Next, we've got the more substantive pieces. So the order really as we've mentioned, appears to kind of respond to concerns about the vagueness of illegal DEI referenced in Executive Order 14173. And instead, it's more kind of clearly defining what it seeks to prohibit. And it's terming this as racially discriminatory DEI activities. And it's defined as disparate treatment based on race or ethnicity in areas like recruitment, employment, contracting, program participation, and the allocation of resources. So notably here, just that reference to program participation may have implications for things like ERGs, which we're going to touch on a little bit later. Then we have kind of the compliance piece here. This order really expands that certification framework, I think that 14173 laid out. And it's, as I think I mentioned earlier, it's now requiring agencies to incorporate standardized contract clauses with 6 specific provisions into all federal contracts by April 25th. And so want to note here that these obligations are going to flow down from prime contractors down to subcontractors, and putting some extra responsibility on prime contractors to kind of monitor compliance and also report non-compliance to federal agencies. And the order is also going to reinforce compliance with these requirements as material to the government's payment. And this is a key point because it's strengthening that foundation for potential False Claims Act exposure. Consistent with that, we've got the order explicitly encouraging the Attorney General to bring or intervene in actions where these certifications are at issue. And then finally, I'll just touch on that the order directs coordinated efforts across OMB, the EEOC, the Department of Justice, and the White House to identify economic sectors that may present a heightened risk. And that really is reinforcing this administration's kind of preferred, unified, targeted enforcement type approach.
You know, one thing, as before David, one thing that we were looking at yesterday in a similar webinar is that David Cohen pointed out, and I did look at it, 11246 has some similar language to what's in this executive order, which I thought which is very interesting.
Yeah, it reminds me a lot of when I was labor counsel many years ago and what blacklisting looked like.
Exactly.
So.
Exactly. This is blacklisting.
Yeah. So for those taking some people back, but it does for me.
I will say, I mean, there are a couple things certainly for contractors. I mean, having a clause, putting in the clause, having it flow down, that is a protocol that people are used to. The clause is quite specific. It's now spelled out. Again, the original executive order lacked that. But the monitoring, requiring contractors to monitor and to basically rat out their subcontractors, that's a new and potentially much more significant burden, and starts to stand up concepts that will need to be further thought through and developed. Final thing, although the agencies are to include this new certification in contracts, as you mentioned, by April 25, we have clients that have already received. So it isn't that they're going to flip a switch on April 25. What appears to be happening is that clients that have general procurement contracts that are triggered through POs, through purchase orders, the government is now, and as recently as last night, sending in purchase orders for more product, services, whatever, as authorized under the contract, and they are incorporating the 6 provisions, or doing a copy and paste of this executive order and putting those in the new contract. So even though we're not at takeaways, I think it does set up, for compliance purposes, your procurement team should be aware and reporting to you if these clauses come in, so you can be sure that you're well positioned and able to go with them. Nita.
And David, I think the other thing, we did a whole webinar on this executive order because we wanted to cover other things here, but it's also important to recognize that this is going to be an agency by agency enforcement. And
Yeah.
so that means you need to check all of your agencies for the clauses because they're going to come from all directions.
Yeah. So I think this 398 is significant. It's different. It's much more aligned with traditional executive orders, not the sort of general social media screeches that we've heard in some of the earlier executive orders. So, and that may reflect they have a more fulsome team at the White House and others working on these matters now, including lawyers. All right. Well, anything else on this slide, Leslie?
Nope.
No. Okay. All right. Let's jump to the next slide. The proposed budget is out, and just as a reminder, the administration proposes a budget. It's their wish list, and we really use that even when they control both sides of both houses of Congress, as the Republicans do now. Rarely do they get what their budget proposes. Okay, it just doesn't go down that way, but it does. It's an interesting statement of the administration's kind of, in a perfect world, this is what we'd like. These represent our priorities, our policies, and when it comes to DEI is all over this budget. I mean, it's a justification for things, and it refers to, eliminating things like cultural Marxism. That is what is attributable to DEI. I mean, it has some sort of we've gotten perhaps almost numb to the nomenclature and some of the screechy tones and characterizations that have come out. But nonetheless, it's littered throughout the budget. With respect to some of the two key agencies with respect to traditional EEO enforcement, the Labor Department, OFCCP, once again, they're trying to put that oak stake through the heart of OFCCP. They tried it with the last budget. They didn't succeed. OFCCP was refunded almost at current level. This time, they're again proposing the total elimination of OFCCP, consolidation of the functions. The Labor Department has an Office of Civil Rights. Candidly, it's kind of a sleepy place. It's like the HR department for the Labor Department. It has some outside-facing functions, but not much. Well, they're proposing amping up the functions for 503 and VEVRA, and interestingly, peeling out the whistleblower, which has always been a weird fit in OSHA. Didn't someone on the Hill do that?
I think so.
Yeah, Leslie could tell us the backstory on how that happened.
Doesn't matter.
Anyhow, there are 27 different whistleblower statutes, and they're all housed in OSHA. They have nothing to do with health and safety generally, but they're in OSHA. So they've said we should reorganize that and put all this in civil rights. It feels like the cats and dogs collection of duties, and they're going to put it in civil rights. EEOC is a big winner on the budget because most agencies are looking at cuts. Leslie, your former agency, ding, 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 4.4% increase.
Yeah, it's big.
Yeah, that's big, particularly in today's world.
And not only that, but they actually have a modest increase in EEOC's staffing, and that almost never happens these days.
Right.
And I think it reflects reality that EEOC is at a historic staffing low. They've lost 10% of their staff, not to DOGE or anything like that, but to attrition and to different government programs. So they need more staff to carry out the administration priorities.
Well, while we've got you, why don't you keep going, and let's kick off some discussion about the agencies. So Sarah, if we can keep moving on our slide.
Yeah.
And first one up, of course, is the biggie, the big kahuna, EEOC.
All right. Well, so before turning to the recent DEI related activity, I think it's helpful to look at the EEOC's fiscal year 2027 performance plan that came out earlier this week on April 6th. That plan references DEI 14 times, and each mention appears in the context of scrutiny, risk, or enforcement. This administration has been clear from day one that it views many DEI practices as inconsistent with Title VII, and the performance plan clearly reflects that. So I think it's just important to mention that. Now, moving on to what we're seeing here, I was reflecting as we were talking today that, this is a letter that Chair Lucas signed this February. I think, it's improved from last February's letters that the law firms received. Those were more individualized. I mean, they were this year. This was more of a general letter. It was sent to all the Fortune 500 companies, not just the CEOs, but the general counsels and the boards of directors. It reminded them of their Title VII obligations in
Leslie,
connection with
the day that letter came out, you and I happened to be having a meeting with Chair Lucas.
Yeah.
We actually were acknowledged as being the first ones to respond to the letter. We had a client who was a recipient. And of course, on the way in, the client said, what are we supposed to do with this letter? And we advised you can effectively throw it in the trash can. It has no legal consequence. But we didn't bother sharing that with the chair.
Well, we just might have, David.
We just said, yeah. But we did. But so yes, but they were very proud of this. And
yes,
it was a promotion. It was just wrong.
It
had no legal consequence.
It talked about, how the EEOC views these issues. It brought attention to, what technical assistance the EEOC has provided on it. It also it included the notable line, "We are the Equal Employment Opportunity Commission, not the Equitable Employment Outcomes Commission," underscoring the Commission's view that it protects equal opportunity and not engineered outcomes. It also reflects Chair Lucas's longstanding criticism of the term equity. And what we're seeing on the ground is that EEOC is pursuing what it views as a legal DEI through the investigative process long before anything becomes public. So we need to keep that in mind as we look at what is public, because Title VII confidentiality still shields the charge stage, and visibility is limited. But across our matters and conversation with other practitioners, the pattern is consistent. The agency is using commissioner charges from Chair Lucas, back from the former administration, and also expanding some older charges that were still at the commission on individual matters that raise some of these issues into systemic investigations. They're issuing very large, very complex RFIs with short deadlines, and they are deploying subpoenas earlier and more aggressively. Now, how often they are deploying subpoenas, we have no visibility because that is not public. But DEI is also now a standing investigative category, even when the original charge had nothing to do with DEI. And that's fully aligned with the administration's public posture on enforcement, as we'll discuss. So let's move on to the next slide.
Yeah, this enforcement has garnered a lot of headlines, and that's clearly what the EEOC intends.
Yes, but
they've flogged those. I think so. Is it all just bedazzle, or is there substance behind these headlines?
Well, there's headlines, but there's very little output, and that's why I wanted to emphasize that, so that you have to be aware that there's a lot going on, a lot of pain going on behind the scenes, a lot of views that employers can just push a button and their applicant trafficking system and employee system will just spit out all the information the EEOC wants and other information. But turning to actually subpoenas, this is definitely a place where we can see how the agency is pursuing what it views as unlawful DEI. To date, the EEOC has only brought 2 subpoena enforcement actions focus exclusively on these DEI issues. The first was filed back in November against Northwestern Mutual, and it sought information about that company's DEI policies in connection with a promotion denial of an employee that was an individual charge. The second is the Nike action, and that's really took the world by storm in February, and that stemmed from a 2024 commissioner charge that had been filed by then Commissioner Lucas. And that case centers entirely on Nike's DEI initiatives and whether they violate Title VII. Now, both cases are pending in federal district court, so there are no judicial rulings yet confirming how far the EEOC can go in using its subpoena power to probe employer DEI programs. But what we do know is that EEOC subpoena authority is extremely broad, and the agency doesn't need a lot of probable cause or proof of violation, only that the information sought shed some light on the allegations, and courts have been historically highly deferential to EEOC. Now, these two EEOC DEI cases will show how the court, how the courts will deal with this, and whether they'll give any additional scrutiny. And they certainly won't resolve every issue moving forward, but they should offer some meaningful signals about how much latitude the agency will have. A useful example, even though it's not a DEI case, is the University of Pennsylvania subpoena enforcement action. In that matter, UPenn and several other interveners objected on privacy grounds, arguing that turning over names and contact information of Jewish employees raised serious confidentiality, constitutional, and safety concerns. The subpoena frankly touched a cultural nerve, and objections went well beyond privacy arguments. And despite those concerns, the court enforced the subpoena. The judge emphasized that EEOC's broad investigative authority, and really was not impressed with individuals' addresses, emails, phone numbers. The only modification which EEOC had already agreed to was delinking the names from the names of the employees from the specific organizations they were involved in. And I think that Penn case is a reminder that courts have been reluctant to clip EEOC's wings and access to information, even when the data is sensitive or culturally charged. And while not a DEI case, we think it's pretty informative. And one of the places we find that our clients, for good reason, do not want to provide the EEOC is employees' individual names and contact information. So
exactly.
yes. So
well, let's keep talking about some of the other litigation developments.
Yes.
Next slide, Sarah. Leslie, I'm going to ask you to keep going.
Okay. So despite the administration's public focus on DEI, and we just talked about the two subpoenas, they've only filed actually just one lawsuit touching on DEI, and that was for the Coca-Cola Beverages Northeast. So it was filed in New Hampshire. This is a Coca-Cola distributor, and it involved a 2-day employer-sponsored networking trip. I think it was to a casino. It was open only to female employees who were excused from work and paid without using PTO, male employees excluded, and the invitations went out quite quietly. EEOC is treating this case as a straightforward Title VII sex discrimination case, the only one of its kind. But the case also illustrates how EEOC is applying the Supreme Court's Muldrow decision, because under Muldrow, some harm to a term or condition of employment is enough. And so EEOC is arguing that denying male employees access to this paid networking opportunity meets that standard. How courts apply Muldrow from here remains to be seen. I also want to talk about the only public DEI-related resolution to date, other than the law firms that settled, and that wasn't so public. And that was of Planned Parenthood of Illinois, and it was a conciliation, which followed a class investigation, which was apparently brought by 3 or 4 employees. EEOC found reasonable cause that the organization discriminated against white employees who were required to participate in race-segregated affinity caucuses and weekly DEI sessions. Some sessions include harassing or derogatory statements directed at white employees. They also is allegations that the white employees were denied certain time off benefits granted to Black employees. And EEOC concluded that these practices amounted to racial harassment, segregation, and disparate treatment. It's important to note that Chair Lucas emphasized that there is no DEI exception to Title VII, and race-based separation or differential treatment is unlawful and violates the federal law. In that case, Planned Parenthood of Illinois agreed to pay $500,000 to implement corrective measures. They removed the manager responsible, and they obviously agreed to make the conciliation public, which is always a bitter pill for an employer to swallow. This again remains the only public conciliation that we know about involving this type of matter.
It's publication because normally a settlement at that stage would not be public, but just to point out, our experience has been that often a demand by the agency in reaching these settlements is, and you will agree to some level of publicity, which is,
Yeah.
effectively you're being asked to waive what the agency could not do.
Right, which is a reason employers like to settle
Right.
conciliation, but it's not unusual. It's not just a Trump administration.
No, it's not here, but it's just
Yeah.
it adds another wrinkle when you're
Yes, and
negotiating.
some EEOC offices are known for this more
Right.
than others.
Planned Parenthood would be Chicago for those that follow
Okay.
places at home. Well, let's talk briefly about some of the federal sector thing, and then
Yes,
unpack some of
okay,
the other.
yes. So finally, this is EEOC issued a federal sector decision in 2-1 vote in February. And it came from the federal sector. By that, we mean the federal government appellate process, which governs discrimination complaints brought by federal employees. It only applies to federal agencies. It does not apply to private employers. And the commission held that federal agencies may maintain sex segregated bathrooms, locker rooms, and sleeping facilities, and that to do so doesn't violate Title VII. This decision expressly overturns part of another federal sector decision, EEOC's 215 Lasardi ruling. That was one of the decisions that under Commissioner Feldblum, EEOC brought out, and that allowed employees to use sex segregated facilities consistent with their gender identity and treated restrictions as potential sex discrimination. So this ruling is important because it signals where the commission may be heading on sex segregated facilities, but it's not binding on courts. It's not binding on federal, on private employers.
Does signal
it's important to recognize that to me, Muldrow would seem to cover, the activities for trans employees, just as you were talking about training and so forth for white employees.
Yes, it gives employers some work to do, but it does not bind employers, and there's issues on both sides that have to be dealt with.
Right. But it does represent pretty definitively what this administration's view is with respect to those issues.
Yes.
And that's the key takeaway.
Yes.
So those employers that want to lower risk of being challenged by this administration have this guidance, can treat it as guidance for their private sector efforts. Anything else?
No, well, we're already behind, so don't ask me. I'll keep talking.
Fair enough. All right. Well, let's go. I want to sort of, as we tour the agencies, because although EEOC is the primary, it's not the only, and certainly the Justice Department has become very active in the private sector enforcement of non-discrimination obligations. So Sarah, can I call on you for that? And Sarah, let's get our slide up. Perfect.
Happily. Okay, so first, I just kind of want to go over some of these policies and initiatives that the Department of Justice has introduced, quite frankly, the past year or so. Then Deputy Attorney General, now Acting Attorney General, had issued a memo last, I think it was May, announcing this civil rights fraud initiative. And this is a focus on the Department of Justice's use of the False Claims Act to investigate and pursue claims really against federal fund recipients that they think knowingly violate civil rights laws. I'll also just briefly mention that on the 7th, so just a couple of days ago, Acting Attorney General Blanche then announced the creation of the National Fraud Enforcement Division, although this was announced technically in an executive order a little bit ago. It's now kind of become a part of the Department of Justice, and it was unclear whether it would have some focus on False Claims Act. It seems at this point in time, they're a little bit more focused on, criminal matters. But the Department of Justice did indicate in its announcement memo that it's evaluating whether to bring in non-criminal components, and that could include the False Claims Act. We've yet to be seen. Then the Department of Justice has been public in what is intending to investigate, at a kind of Federal Bar Association conference recently, Deputy Assistant Attorney General Brenna Jenny kind of went through what exactly the Department of Justice is focusing on with respect to its investigations, and really said it's focused on three things. One, companies that are setting and tracking workforce demographic goals. Companies that tie executive compensation to diversity metrics, and also companies that are requiring employees to meet DEI-related goals that are impacting compensation or promotion. So really, we can think of these as the practices that the Department of Justice views in need of or wants to further scrutinize. So for them, we've got their enforcement efforts. So while they're certainly vocal about wanting to bring FCA or False Claims Act actions against contractors and subcontractors that are violating these certifications, we've yet to see one of these go as public as the EEOC matters have gone. But again, they've continually publicized that is what they intend to use the False Claims Act for, in addition to all the other things that they use it for. And lastly, I'll just mention that their enforcement is not just limited to federal contractors and the False Claims Act. They've also recently, I believe it was in January of this year, had filed a lawsuit against the state of Minnesota, challenging the state's affirmative action program as really violating Title VII by using race and sex as a factor in hiring. That's the allegation there. So that's kind of just a brief overview of where the DOJ is headed or where they intend to head.
That's an excellent sum up. I just would add that on this FCA enforcement, we do know that some employers have received civil investigative demand, CIDs. It's an investigative tool. It's effectively an administrative subpoena for a broad range of documents that are tied to DEI-related investigations and potential FCA, False Claims Act claims. So typically, the agency may be involved for a period of many months or sometimes years as part of their investigation before you publicly can tell that there's actually a False Claims Act going. So our best educated guess is there is a fair amount of FCA activity relating to DEI happening, and the clear thrust is, and there's going to be more. Mm-hmm. Yeah. So I think that's a fair takeaway. All right. Well, but as they say, but wait, there's more. So yeah. Nita, how about that FCC, Federal Communication Commission?
Yep. And I'm going to do these quickly because we want to have time at the end for the takeaways. So first of all, in the FCC chairman, Brendan Carr, we've talked about this before. He is requiring employers who are engaged, have a merger that requires FCC approval, to either eliminate or substantially change their DEI programs. We have spoken in the past. I mean, so far it has impacted Verizon, Skydance, T-Mobile, and AT&T that we know of. And we assume others have seen that as well. So let's go to the next one as well. And that latest one was in December with AT&T. Also, as we've talked about, we had the FTC sent a letter. This is very unusual. They sent a letter to 42 law firms that participate in Mansfield certification, which is doesn't have goals. It has, like aspirational type things, arguing that it may violate antitrust because they talk about what they pay people allegedly. So that's interesting to see the antitrust used in this way, warning that it doesn't ask the law firms to do anything, but it says that their quota-like practices and shared targets could distort competition. And even though in the Perkins-Coie EEO or EO litigation, the judge found that the Mansfield certification is not a quota system. Mansfield and in fact, all of this activity has just about destroyed Diversity Labs, which created the Mansfield certification. So many law firms have moved away, which I believe was the whole goal of all of this.
Of course. Just an observation. The Federal Trade Commission and the deployment of the antitrust laws to deal with labor and employment enforcement, because most people didn't think the antitrust laws had a lot to do with labor, although there are some exemptions for sports players and things like that.
The anti-poaching, they got a little into that.
Well, they got that, and then for baseball and others, so the players. But anyhow, I've always thought that represented good lobbying to get those industries carved out more than anything. But in the prior administration, we had antitrust laws being used to challenge non-compete agreements and other some joint employment standards and so forth. Obviously, this administration's not on that page, but they're now on the page of whether effectively a DEI related, this is part of the highly animated DEI challenge, potentially using the antitrust laws and using, again, we're back to the playbook of leaning into institutions that are influential. 42 of the nation's largest law firms. The thought is if you can get the law firms to back off and be aware of some of this, they will also transmit that experience to their thousands of clients.
But what we don't know, is it an empty threat to get it to back off, or is it a harbinger for things to come, other diversity, initiatives? Because it's the same thing can apply. There's diversity initiatives in lots of different industries.
Correct.
So
that's right. And at this point, and it was clear, as Nita mentioned, these letters didn't say that any one of these firms had violated the antitrust law.
Right.
It was kind of like the Andrea Lucas letter we talked about before. Hey, just remember,
yes,
there's these requirements out there.
Right. I mean, our benchmarks, when is that collusion, I think is what they're suggesting. Okay.
Well, in addition to the federal agencies, and those are certainly the rundown of the primary federal agencies, notice that labor is not a strong player except for a fairly limited role for 503 and VEVRA, generally speaking. But the states are picking up efforts, and let's quickly touch on some of those. Nita, maybe you can kick off that first piece.
Sure, and let's just go to the next slide. We're just going to do quickly because we want to get to our takeaways. We have some really great ones. Just so you know, Texas and Florida, among many other states, on MLK Day, I might add, issued legal opinions that certain DEI and affirmative action programs constituted unlawful discrimination. And oh, by the way, the Texas Attorney General is running for Senate in a very tight race against the incumbent, just so you know. We have Tennessee ended the collection of workforce data on women and minorities. Ohio has repealed requirements to maintain and report AAPs for utilizing economically disadvantaged persons. And there are a whole bunch of proposals in the states you would expect, the red states, to eliminate affirmative action. And there is a move to get the Supreme Court to overturn the one decision where you could have voluntary affirmative action. But David, I know you want to talk about this last one.
Well, I'll just jump on Florida. So in Florida, the Attorney General there basically sent a warning letter to the National Football League saying, by the way, the Rooney Rule, which is a diverse slate rule, it's where first the diverse slate concept first developed and evolved in the professional world of the NFL, and noting that he believes that that the Rooney Rule may violate their state laws, state EEO laws. Interestingly, the NFL's response was sort of, well, whatever, we don't care. We're not changing. We're not doing anything different. They basically said, as far as we're concerned, we're doubling down. Come get it if you want it. And I thought that was a fascinating response, quite different than a lot of corporate folks that don't want to engage much on it. They were like, we're proud of the Rooney Rule. We think it's been successful. We think that it's resulted in an organization that has predominantly African-American players and used to have almost exclusively white head coaches, certainly, that we have succeeded. And the Rooney Rule is part of that in having a more diverse effort in our coaching and other leadership.
More diverse. I mean, I think that's one of the reasons they could say it.
Well,
it's an important idea. Yes.
And the NFL's response is, and that's the reason we're not taking it down, because we're not
right. If it was wildly successful, maybe they couldn't do that. But that's
so. But it's interesting because it stands out. Again, it's an attempt. It's a little showboaty by Florida to pick on the NFL and sort of call out the Rooney Rule, but it's also a different response than a lot of private sector employers have. The NFL standing up, sort of thumping its chest, saying, "Yep, come on, we'll talk about it. We're not changing it. We disagree," which is so. We do have eyes on that particularly. I think that's worth noting. Well, anyone have anything else on state law developments? I mean, there's a lot of other red state activities, but for the interest of time, we'll chop those. Okay. And I just would note as a footnote, sorry, before we leave states, there are some blue state activities where they're actually enhancing some of their DEI protection. So it's kind of like a balloon. No matter how much you push in on one part, the other parts bulge out, and that is
the multi-state employer's dilemma.
Multi-state employer dilemma, as New Jersey has codified disparate impact and doubled down on that very recently. It just continues. So, all right. Well, let's go to takeaways, because I think this is where we can really delve into things a little bit and make sure that some of the lessons that we've learned that we do want to share with all of you that hopefully will be helpful. So, Nita, maybe you can start us on some of the data collection and analysis, which is always a big question. Do we still do it? How do we do it? What are we doing?
Yeah. So after 14173 went into place, there were a lot of concerns about whether, because the way that federal contractors collected applicant data and then did the analysis was under the requirements of 11246. Now that's gone. You still have to, at least for now, collect employee data. But I think with the requirements of the new executive order, I think it is absolutely necessary for employers to continue to collect and analyze race and sex data in their employment decisions. And I would even say you might even consider, because of Muldrow, to also look at training and leadership development and other things. Now, when you do this, there are a couple of things you need to know. Chair Lucas has told us she's okay with you doing these analysis under privilege, but don't share them widely, because that looks like you're engaging in illegal discrimination, decision making, blah, blah, blah. And what you really should be doing is if you find problems, then go to the people and figure out what the issue is to avoid potential discrimination of any kind. And as David mentioned earlier, federal contractors are going to now have to figure out how they are going to review their subcontractor compliance around non-discrimination under these new requirements.
Yeah, data collection, most employers that have federal contracting obligations already have the muscle memory, the process. You need to change the form, make sure it notes that it is voluntary, and many applicants are quite used to this. And I think we certainly regularly do recommend that clients continue this practice with the protocols that Nita's laid out here. I mean, you got to be careful what you do with it. But all right. Anyone have anything else on data collection? No? Going once, twice? Next. ERGs. What a lightning rod they have become. Wow.
That's just what I was thinking. Like the data collection to you is like the ERGs for me. Right. Yeah. Look, ERGs are under fire, but I think the fire may only be starting, but I still think they're important. So let me preface all that with this. You have to take a look at your ERGs. They have to support your organization's culture, your business objectives, talent strategy, but they also have to be structured in a way that complies with Title VII. And so this is a good time, and I know employers, you've already looked at your ERGs, and hopefully you still have them, or maybe you still have them, or maybe you decided they weren't working for you. But if you do, it's time to reassess whether your existing ERGs still align with your company's goals, and whether your process for creating new ERGs is clear, fair, and consistently applied, because others will be applying. So that includes taking a look at your ERG charters. Hopefully you have that, membership criteria, leadership selection processes, governance structures. Employers obviously should confirm that ERGs are in fact open to all employees, that participation is voluntary, as we saw in the Planned Parenthood, like the training or separating folks. and that the purpose and activities of each ERG is tied to a legitimate business objective, such as engagement, retention, community building. Second, reassess your ERGs in light of the current legal landscape. And we've talked repeatedly here about the recent EEOC activity, and I think the executive order focusing on whether DEI-related structures limit, segregate, or classify employees based on race and sex. We've already said they have to be open to everyone, and events and programs can't exclude employees based on protected characteristics. And but there are other issues too. I mean, even though the law hasn't changed, the scrutiny has, and ERG activities must be inclusive, and they have to avoid the appearance of segregation or differential treatment. But there's more. There has been some incremental, we're seeing it, pushback against ERGs organized around race or sex. And I think we should expect sometime in the very near future a direct challenge to an ERG simply for being identity specific. For example, why does a group called Hispanic female engineers exist at all? I think it reflects a broader trend that we are seeing, like we've seen in the executive order language. So employers should be able to, be prepared to articulate the business purpose of these groups and how they operate in a non-discriminatory way, because there are benefits to the business. So when structured correctly, ERGs support engagement, retention, and culture, and those things are good things. So they create community. There's lots of good reasons. Just don't forget them and keep them in mind as scrutiny increases.
I think it's just a matter of time. Certainly the new executive orders, the proposal in the GSA reg that we talked about earlier in this discussion, all tee up the possibility. They provide foundational elements for a direct challenge for a group that's based on race or ethnicity to be directly challenged simply because that is the organizing principle, even if it otherwise meets what we believe are all the Title VII requirements, that having the group alone. I predict, I'm very confident we'll see that in the next couple of months, if not sooner.
In the meanwhile, make sure your leadership development, mentorship, and internships are not tied directly to your ERGs.
Agreed. Good. Training. Nita.
Okay, well, I'm going to do this fast because we're running out of, we've got so much going on here. I really think you've got to refocus your management employee training on compliance with federal non-discrimination laws and really help everybody understand. Yeah, I know the law hadn't changed, but the entire environment has changed. And especially you need to get your HR people understanding that if they have a white employee complaining, you make sure you investigate it like you would anybody else and don't just, blow them off. This is really a big problem I'm worried about because those people have the opportunity to go to DOJ and become a relator, a whistleblower, and you don't want that. And I think that, if you continue your DE&I training, perhaps you want to look at something like civility training rather. Make sure if you have it, it's voluntary. People are allowed to say, I don't want to participate because of my religious beliefs or whatever. And you really need to make sure that any training you are using does not disparage any group. Do not say that white people are evil or discriminatory or whatever, which some of the training said. The Planned Parenthood training should be a lesson to us all. Leslie?
Yeah, I was just going to add, make sure it's focused on behavior expectations and not identity-based generalizations, right. And avoid stereotypes of groups and double check your vendor's materials. It's just like testing. You are responsible for whatever your vendor puts out, and you may assume they're super savvy, and they will tell you they are, but they may not be. So you're ultimately responsible for it.
That's a great point, because most of the people who have gotten in trouble, it's been due to their own vendors and what they've done. They thought they hired experts and they got burned. All right. Recruiting, another big area of activity.
Yes, of course. So like Nita, I'll make sure we address these quickly since we're nearing the end of the hour. But nonetheless, I think we first want to address outreach and recruiting. So really, employers can still engage in outreach and recruiting efforts with diverse schools, professional organizations, geographic markets, recruiting channels, all of these things. But the emphasis needs to remain on expanding that pipeline and not narrowing the selection decisions. I think as we've kind of discussed the diverse slate issues, the Mansfield rule or Rooney rule type consideration requirements, on paper, these programs are just structured as consideration requirements, not quotas, but in practice, how they're implemented and communicated really matters. So kind of keying into those and recognizing that right now they are at high risk of, further scrutiny. And then lastly, we have here, that, and again, this kind of comes up with the DOJ's focus, right? It's going to be with what incentives are tied to, demographic targets and things like that. So while this might have been done already, making sure to do it again with that kind of focus that those requirements are eliminated.
Cool. I agree with that. And this recruiting and the diverse slates, Mansfield rule, et cetera, they are all over this. There will continue to be lots of activity there. All right. Well, let's go. We're going to do a quick lightning round robin. Final thoughts. Nita, I'll pick on you to go first, if that's okay.
Well, I'm going to reinforce you need to continue to collect applicant and employee data and do analysis, although you don't distribute it. When you do the analysis, remember, you have to follow up if you find a problem.
Good enough. Leslie.
You all may be sick of hearing, talking, thinking about DEI, but we're all seeing it has many lives in this administration, and you need to keep on top of these issues because the landscape is changing every day.
Great point. Sarah?
For some reason, all of my points today have been related to the DOJ, so I'll stick with that theme. And really, I think the point is that DEI is increasingly being kind of treated or framed as a fraud issue. So we're keeping an eye out for, how to prevent those types of claims.
Final thought I'll offer up is that particularly for contractors, grant recipients, those that receive federal financial assistance, after about 12 to 15 months of the administration sort of going from general statements about illegal DEI, they're starting to get into much more of an action mode. There are going to be specific regulatory requirements, there's going to be specific contractual requirements, and there's going to be consequences on a multi-agency basis. There is an absolute commitment. It is going to happen. I feel firmly about that. I also would like to just give a shout out to our podcast that we're just dropping, where we do unpack the most recent executive order and some of the requirements there. It's a great podcast. Please give that a listen. And that's just one, we do these webinars. I want to thank everyone for, this is the third of the 3-part series that we've done for the spring session. We're going to give ourselves, a day or two off. No, we'll take a little bit of time off, but we'll stand up another multi-part webinar coming in the summer to keep people apprised of the developments. The podcast, though, does represent other alerts. If you're interested and you're not on that list, want to be alerted, get in touch with us and we'll be happy to have you join us. So again, with thanks. And Sarah, I'll go back to you.
We'd like to thank you all for joining us today. If you have any further questions, please email us at info@FortneyScott.com. A recording of this webinar and a copy of the PowerPoint will be available to all those who attended. This will be sent as soon as the webinar recording is available. Stay tuned for our next podcast and webinar.